Okay, so welcome everyone, and tonight this is the second tutorial we have in administrative law, and we will talk about the framework for judicial review. And before I proceed, I wish to thank Sarah Lorraine, Sarah Rogers, and Sarah Goodchild. There's SB, I don't really know who that would be. There's also Kayla, Jackson, Daryl, Mike, Lauren, Daniel, Nicholas, Steph, and Bronwyn. So that we have about 15 students tonight. We also have Michael, and I suppose there will be other students who will be joining us later on. I may have missed some other students. Now, I wish to point out that I can't really see everyone on the screen. There are only about 5 people who I could view on screen. So if you end up raising your hand, visually, I may not be able to see you. So you might have to unmute yourself. Okay, so having said that, thanks for joining tonight's session. And we are talking about a very important topic on administrative law, and that's the framework for judicial review, mainly because, I'm gonna have to turn off my fan, mainly because assuming that there has been a decision that, Manjo is talking, okay. Wait, can you hear me? Okay, very good, because I thought somebody was saying they couldn't hear me. Okay, now where was I? Okay, so assuming that an administrative decision has been made and you are unhappy with the administrative decision, and assuming that the executive refuses to change or revise the decision it has been made, the question is, what options do you have? And what we need to remember is that if you examine the framework of government we have, the framework of government, we know that there are 3 branches of government. Wait, Daniel is saying she hears nothing? Hang on. Are people able to hear me? Oh, okay. So Daniel says she could hear me now. Very good. Okay. So if you look at the framework of government, we know that there are 3 branches of government. You have the executive, you have the parliament, and you have the judiciary. Now, if we assume that every single decision of the executive can actually be reviewed by the judiciary, isn't that kind of saying that the judiciary is in fact supreme over the executive? Wouldn't that make sense? So assuming that, let's assume that a decision is made by maybe by Centrelink. It could be a decision made by the Department of Home Affairs about an immigration matter, or it could be a decision made by the Child Support Agency. And let's assume that the decision to a potential applicant feels, that potential applicant feels that the decision aggrieves him or her because the decision is wrong on the basis of certain facts. Or it could be that the person feels that the decision is wrong because the policy has wrongly been applied. And imagine that every single time a decision is made by the executive, it is subject to the judicial review. And therefore, the judiciary is in a position, therefore, to use its own policy decisions to override that of the executive. And it could be questions about pertaining to tax matters. What if the judiciary can say, oh, it is wrong for the parliament, for example, or even for the executive to decide that tax rate should be about 40%. Or it is wrong for the executive to favor maybe the disadvantaged over those who have more money in society. In other words, we're talking about political considerations getting into the picture. Then we could probably argue that in that case, the judiciary appears to wield more power than the executive and even the parliament, because the judiciary in that case would then be in a position to override policy decisions made by both the executive and the legislature. But that becomes problematic in the framework of government, mainly because the judiciary, the members of the judiciary are not even elected officials. They are appointees, as opposed to the people in the executive and primarily the people in the parliament, because they have been elected by citizens, and therefore they can be said to be representative of society. And so therefore, we now see that when it comes to judicial review, we need to know that there ought to be limits to what the judiciary can review as far as decisions made by the executive are concerned. And we will examine that. And we will then see that as far as judicial review is concerned, the scope of judicial review is actually limited and it is narrow. Okay, it doesn't review all executive decisions. And it is also important for us to realize that even assuming that there is a ground for judicial review, maybe because the executive has wrongly applied the law, maybe the executive has failed to take into consideration certain factors that a legislation requires to be considered, or it could be that there has been a breach of the principles of natural justice, meaning the requirement that a person should have been heard before a decision has been made, which has an effect on the rights or interests of or legitimate expectations of a person. Assuming that the principle of natural justice has not been observed, then that becomes a ground. But even assuming that there is a ground for judicial review, we then realize that there is a question of whether or not there is a proper judicial review remedy. So these are things that we examine in the course of looking at judicial review. And of course, the specific grounds for judicial review will be examined, I think, starting in week 4 up to week 9. And then we devote week 10 for the purpose of examining judicial review remedies, because we will later see that even though a court may acknowledge that the executive has made a wrong decision, even assuming that the courts feel that the decision is invalid according to the law, meaning the decision by the executive is unlawful, there will be times where the judiciary is unable actually to provide the proper remedy, and is unable even to grant the specific remedies requested by an applicant. So for example, an applicant may say that, let's say that an applicant had asked for particular Centrelink benefits and Centrelink said, no, you're not entitled to it. And so therefore the applicant may decide at some point to go to the courts for the purpose of compelling the child support agency or Centrelink to give particular benefits. But actually we will later on see that the judiciary in general does not have the power to substitute its own decision for that of the executive, and cannot compel the executive to act in a certain way. So there are constraints to judicial review. And in the course of our tutorial tonight, we will also realize, we will also be looking at when judicial review is actually available. Is it available in all cases every time the executive makes a decision? So what if the decision is not even final? What if it is what is known as an intermediate decision? So let's say somebody is trying to apply for a particular benefit before a particular executive agency, and that person is being required to submit documents, and the person is unable to provide the documents by a deadline, and so that person requested for additional time to submit the documents, but the executive refused to provide, to extend the deadline. With that particular decision, which could obviously lead to a denial of a benefit, is that particular decision subject to judicial review if it is an intermediate decision? And so we're examining that as well, especially when we examine one of the cases tonight, if you have the time, which is the case of Australian Broadcasting Tribunal versus Bond. And the other crucial point we will also see is that when we speak of decisions made by the executive, and we need to kind of look a bit into constitutional law in this case, we will realize that even as far as the executive is concerned, there are various sources of executive power. So for example, under Section 61 of the Australian Commonwealth Constitution, the powers of the executive are actually reposed in that particular provision. And yet, apart from Section 61 of the Australian Commonwealth Constitution, we know that there are certain implied executive powers. This is so because there are certain countries, there are certain states, and when I speak of a state, I'm talking of nation states such as the UK or New Zealand. We know that there are certain states such as the UK or New Zealand where they do not have any constitution, such as the one we have in Australia. So if there is no constitution, such as in the UK and in New Zealand, what then is the source of executive power? Because they don't have a constitution. In Australia, we could say that the power of the executive is based on Section 61. But what about those countries where there is no written constitution? Where then lies the power of the executive? And then we realize, therefore, that for any government to be able to function, for any society to effectively function, you need to have implied powers of the executive. The executive is the one that usually implements the laws, but more importantly, it is responsible for ensuring that certain benefits and certain services are provided to citizens. That is not the job of the judiciary. That is certainly not the job of Parliament. That is the job of the executive. And so therefore, we realize that on top of, or even in the absence of Section 61 of the Australian Commonwealth Constitution, we have to understand that there have to be certain implied powers of the executive. Okay, and these are often called the prerogative powers. So the power of the executive, for example, to create departments. You do not need a power from the Parliament for that. The power to enter into contracts, the power of the executive to enter into treaties, the power of the executive to enter into diplomatic relations. These are some of those which are considered to be implied powers of the executive. The power of the executive, for example, to exclude aliens, and so therefore both refugees from entering Australia. That is considered an implied power. Now, so I've already talked about two sources of power of the executive, and I will go back to why this is important in a short while. So we know that there's Section 61 of the Australian Commonwealth Constitution, which is a constitutional basis for the power of the executive. You have what are known as implied powers of the executive. Typically, they're called prerogative powers of the executive, which are inherent in the executive for it to be able to function. There is a third source of power, and that is the Parliament typically provides what is known as a primary legislation, authorizing the Parliament to act in its behalf. So there could be a primary legislation from the Parliament, and then it authorizes the executive to thresh out the details of that particular enactment or that particular statute. So those are at least three of the sources of the executive power. Now, that is a crucial point because one of the major innovations that has happened in Australian administrative law is the enactment of what is known as the Administrative Decisions Judicial Review Act of 1977 Commonwealth. And as a result of that particular statute, whereas in the past, if you needed to seek judicial review, you usually relied on what is known as common law judicial review, meaning the inherent powers of the courts to police the exercise of executive power, or you could have relied on Section 39B of the Judiciary Act of 1903 Commonwealth, and I think I'll have a chance to discuss that in a short while. But the ADJR Act of 1977 Commonwealth was in a sense a codification of the grounds for judicial review, as well as the judicial review remedies, and then an identification of the particular courts in the federal judicial system that had a power to undertake judicial review. However, as far as the ADJR Act is concerned, although it is very important in administrative law because it kind of simplifies and puts into one single statute the grounds of judicial review as well as the remedies of judicial review, the ADJR Act is not available for all executive decisions, but only decisions made under an enactment, as we will see later on. So it's kind of complicated. And then you've got questions about standing, you have questions about the need to make sure that the decision is actually a justiciable decision. And that, I think, is one question we'll be covering tonight. So having said that, after going through tonight's topic, hang on, am I speaking too fast or just okay? So I'm good. Okay, very good. So after studying this topic, you should be able to discuss and explain the concept of judicial review and when it is available to review administrative decisions, the framework and legal basis. Thank you. I'll get back to Kayla in a short while because I think she has a quick question. The framework and legal basis for judicial review in Australia, the requirements of justiciability in judicial review, the instances when an application for judicial review under the ADJR Act can be made, the jurisdictional requirements of the ADJR Act, and particularly what decisions are covered under the ADJR Act, and what is meant by decisions to which the ADJR Act applies. like decision of an administrative character and decision made under enactment. Okay, before I continue, Kayla, I think, has a quick question. Kayla, you have the floor.
Hi, Manjo.
Yes, very good. Yes.
I've just typed the question because I just would like to know, if you can't make the AJRA work for you, can you then rely on the common law
to
make a decision? I'm just a bit confused about the two whilst I was reading through the textbook. It wasn't clear to me.
Yeah, that's a very good question. And so before I address that particular question, Kayla, what we also need to remember, and this is the topic we're discussing in week 3, in terms of a review of administrative decisions, you can actually have what is known as a merit review. A review, for example, by the Administrative Appeals Tribunal. But we will see later on that there are restrictions when it comes to applying for a merit review with the Administrative Appeals Tribunal, because as we see later on, not only must a decision be made under an enactment, there is a requirement that that particular enactment itself must authorize a review by the AAT. As opposed to the ADJR Act, the requirement under the Administrative Decisions Judicial Review Act of 1977 Commonwealth is that a decision is made under an enactment. In other words, it's made under a statute. And so for as long as it is made under a statute, there is no requirement that that particular statute provides for a remedy for judicial review. It is sufficient that it is a decision made under an enactment, as opposed to the AET Act of 1975 Commonwealth, which requires that the decision is made under an enactment, and the enactment itself must provide for an application for judicial review, an application for merit review to be available with the AAT. Now, having said that, the other thing we need to point out is that apart, and I think I alluded to this earlier already, I mentioned this earlier, even assuming that a decision is not subject to the judicial review under the Administrative Decisions Judicial Review Act, mainly perhaps because the decision was not made under an enactment. So let me repeat. Assuming you have an administrative decision, so it is an administrative decision, okay? Assuming you have an administrative decision and the decision is not made under an enactment because perhaps the decision is made on the basis of an exercise of the prerogative power or the implied powers of the executive. It could be the power to the general power to enter into contracts. It could be the power of the executive to exclude aliens. So it is not based on a statute, but the exercise of implied powers of the executive. And because it is a decision that is not based on an enactment, therefore you cannot seek recourse under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. What then are your options? Well, apart from common law judicial review, you actually can ask for judicial review on the basis of 2 other provisions of law. One is the Constitution, because under Section 75(5) of the Australian Commonwealth Constitution, the High Court has original jurisdiction to review, to issue writs of mandamus or prohibition or an injunction against an officer of the Commonwealth. And then Nicholas, I'll get back to you in a short while. I saw Nicholas raising his hand, thank you. So are we clear about that? So there is Section 75(5) of the Australian Commonwealth Constitution. Now Section 75(5) of the Australian Commonwealth Constitution actually has a counterpart in Section 39B of the Judiciary Act of 1903 Commonwealth. And in that particular provision of the Judiciary Act of 1903 Commonwealth, it also provides that the Federal Court of Australia has the power to issue writs of mandamus or prohibition or an injunction against an officer of the Commonwealth. Now, so the problem, however, therefore, as you will see, is that if you rely on Section 75(5) of the Constitution, or you rely on Section 39B of the Judiciary Act of 1903 Commonwealth, the remedies are restricted only to the writs of mandamus, the writs of prohibition, or the writs of injunction. Now, I will not get into the details of these particular remedies because they can get confusing at this time. We will take them up in week 10. But I would like to caution you already that at that point, there are only 3 recognized judicial review remedies under Section 39B of the Judicial Act of 1903, as well as Section 75(5) of the Australian Commonwealth Constitution. Now, assuming that it is a decision that is made, it is an administrative decision, assuming that it is a decision that is not based, assuming that it is a decision where you cannot seek a writ of mandamus or prohibition or an injunction, and we will see later on there are other judicial review remedies, then it is possible actually to seek recourse to the common law jurisdiction of courts. Now, what I need to point out is that what exactly is the common law jurisdiction of the courts? The common law jurisdiction of the courts, the exercise thereof, traces itself back to 1644, when there was a battle between the King of England and the judiciary, where the judiciary stated or emphasized that it actually had the power to control the exercise of the king. So if you look back historically about almost 400 years ago, you will see a tension, a battle between the king, who is monarch, and the king usually is absolute, right? At that time, whatever the king says is the law. But at that time, the judiciary was saying, we have the power to actually police the exercise, even by the monarch, of its prerogative powers. And so, as a result, that is what is known as the common law jurisdiction of the courts. And the common law jurisdiction of the courts is an assertion by the judiciary of its inherent power to ensure that any actions by the executive is according to the law. And so, for example, we will examine, I think, the principle of legality here, is it? And then we realize that, for example, for the executive to take an action against a citizen, and where that action has the effect of affecting the rights or the privileges or interests of that individual, the executive must be able to point to a positive law. And when you speak of a positive law, it actually means that there has to usually be a statutory authorization. So, for example, the executive cannot say that it has the power to enter into the house of an individual on the suspicion that that individual might be involved with terrorism without a statutory authorization. In other words, without an enactment coming from the parliament authorizing the executive to enter into the house of an individual, for the executive to just get into the house of an individual would be a violation of the law because of the principle of legality, which I think would be something that I think is taken up at this time, or is it in about 2 weeks' time? Okay, did that answer your question, Kayla? Okay, thank you, very good. Now, Nicholas, I think I saw you raising your hand.
Yeah, Manjo, just a quick question, as long as you can hear me.
I could.
Okay, so my question is about the ADJR Act itself. Now, we're looking at this Act, and it obviously restricts what we can do as far as taking this to a judiciary review or judicial review when it comes to government action. The question juxtaposed here is that it's the legislators that created the ADJR Act to begin with, right? As part of the legislators is the executive government, correct?
Wait. You're saying that the executive is part of the legislature?
Yes.
Okay. Well, under the Westminster system of government, yes, because
yeah. Okay. So the bottom line here is that the government, with the help of the legislators overall, with the executive being part of the government, has written its own act to preclude what we as the public can and can't do as far as taking the government to a judicial review. End of story.
That's right.
Yeah. So when we're talking about separation of powers, where does that come into play when the government is becoming judge, jury, and executioner under the ADJR?
Okay. I can answer that, Nicholas. That's a very good point. I'm not going to address the issue of separation of powers at this time, because I think I addressed that in one of the the Word files that I sent there. I could discuss it in a short while, but I won't at this point. I assume you know what, most of you generally know what the separation of powers is concerned. My answer to that, Nicholas, is that I'll give a particular example. Let's assume that the parliament passes a law, and it says that the decisions made by the executive cannot be reviewed by the judiciary in any event. Okay, so let's repeat. Let's assume that a law has been passed by the parliament, and that particular law or enactment provides that any decision by the executive, it could be about matters of terrorism, national security, matters pertaining to immigration, whatever. And let's assume that that particular enactment provides that any decision made by the executive in relation to any of those subjects of the law are beyond the power of judicial review.
Yeah, and that's my point, Manjo. Isn't it within the ADJR Act that it specifies certain sections of the executive government that cannot be challenged under a judicial review? And reading over it today, it lists some things. So like the Intelligence Act, and there are a couple of others. So now what you're telling me is that, once again, we actually have no recourse at all if they decide that they want to list in the ADJR Act at any time. Let's say they review it and they add in more departments. Yeah. Where do we go then?
Okay.
Manjo?
Wait, hang on. I actually wasn't finished yet, Nicholas. The point is, and I think, no, it's not being part of, it's not a part of administrative law. It's actually part of constitutional law. If we study constitutional law, we realize that there's a difference between what is known as an ouster clause. So an ouster clause is one where it prohibits the judiciary in all events from examining the lawfulness or constitutionality of an executive decision. The courts have said that that is not allowed, because under the framework of government in Australia, there has to be a body, and that is the judiciary, which will always have the power to review decisions by the executive when it is not in accordance with the law. So the parliament, therefore, does not have the power to absolutely prohibit judicial review, mainly because under Section 75(5) of the Australian Commonwealth Constitution, we know that the High Court has original jurisdiction to issue writs of mandamus or prohibition or an injunction against an officer of the Commonwealth. So to that extent, we need to realize that the Australian Commonwealth Parliament does not have the power to just, exercise its prerogatives to prohibit judicial review, because that is what is known as a constitutional writ. Now, at the same time, we also need to point out that as far as the common law jurisdiction is concerned, we know that courts will always be prepared to exercise its inherent power to police executive action when it is contrary to law. Now, going back, therefore, to the issue of the ADJR Act, the whole point of the Administrative Decisions Judicial Review Act, according to the Commonwealth Parliament, is simply to provide a way by which, the grounds for judicial review and what judicial review remedies might be are, in a way, are simplified. So you have, you can just look at one law and what the grounds are and what the remedies may be. Now, at the end of the day, we know in Australia that the Commonwealth Parliament has absolute power to pass any law for as long as it is within its jurisdiction, as far as the Australian Commonwealth Constitution is concerned, for as long as it is not against the Constitution and it is not against those powers which have been reserved by the Constitution in favor of the states. And for as long as, it is within the competence of the Commonwealth Parliament to enact a particular law, courts will not ever strike down that particular law to be invalid.
Yeah, so that's the big question then, isn't it? Because what it means is that if you challenge the law under the ADRJ, then a judge can give you a decision to say that what was done to you may be incorrect, but they can't force anything other than to send it back to the executive to ask them to review their initial decision. The court has no standing to override that law whatsoever. So I think you said before, it's almost a waste of time and money, because you're being sent back to the people that made the initial judgment, and all they're going to do is take wind of what the judge said and change their attitude towards you slightly and still penalise you in the end. And sometimes maybe worse for taking them on through the ADJR.
Very good. I'm going to go back to what Sarah is saying in a short while, but Nicholas, very good points you've raised there. Let me just make a clarification though. What we need to remember is that when we speak of judicial review, we're speaking of a review of administrative decisions. Judicial review does not involve a review of the legality of an act of parliament that is part of constitutional law. So when we speak, for example, of judicial review in administrative law, we're speaking of decisions made by the executive which has an effect on a particular individual. And that is now what is subject to judicial review. And in the course of an examination of a decision made by the executive, therefore, it typically does not consider the constitutionality of the law. It does not. It examines, however, whether or not the decision made by the executive is in accordance with the law. And therefore, an individual who actually attacks a law itself for being unconstitutional, that is not really judicial review. That is more a part of constitutional law. So when we examine administrative law, we're looking at decisions made by the executive. And when it comes to judicial review, the basic question we're asking is whether or not the decision made by the executive is according to the law. And we assume in that instance that the law, as far as the Act of Parliament is concerned, is actually lawful and constitutional. Now, Sarah was saying that we have an option for merit review. And we will later on see that the beauty of merit review, for example, as far as the Administrative Appeals Tribunal is concerned, is that not only does the Administrative Appeals Tribunal examine an executive decision according to whether or not it is according to the law, but it also examines whether or not the decision is correct according to the facts. So it makes a factual determination of whether or not the executive properly evaluated the evidence. But at the same time, even assuming that the executive made a decision correctly according to the facts, we will also realize that when we speak of merit review, the AAT actually has the power to use its own discretion or even apply policy considerations. Now, the use of discretion and policy considerations are beyond the purview of judicial review, because judicial review is all about what is lawful. And issues about factual matters are again beyond the purview of judicial review, as we will later on see. Okay. Now, there is a statement here from Keith. I'm just going to read it quickly. I might have been lost in the thread, but I believe you said there were three options if you could not bring an action under the ADGRA. The first two, I believe, were the common law. So the common law comes in later. And then there's the constitutional provision, section 5.5 of the Constitution. And there is a similar provision, which is section 39B of the Judiciary Act of 1903. That is correct. Now, what you need to remember is that if, assuming that you wish to have a decision made by the executive subject to judicial review, the first port of call is also to ask, can that decision be subject to review under the ADGR Act? The ADGR Act is easier because the grounds are clearer and the scope of judicial review is broader. If you go straight away to section 39B of the Judiciary Act of 1903 Commonwealth or section 75.5 of the Australian Commonwealth Constitution, you're limited to three writs: the writs of prohibition or mandamus or an injunction. Now, only when, for example, so let's assume that there is a decision which is, now, as far as, let me just clarify as well, as far as section 75.5 of the Constitution is concerned, and section 39B of the Judiciary Act of 1903 Commonwealth is concerned, we're speaking of writs of prohibition or mandamus or an injunction against an officer of the Commonwealth. Okay, we're clear? Now, let's assume that an executive decision is made not by an officer of the Commonwealth. So let's assume that you have the ANU, the Australian National University, which has been, has been created under an enactment, and the decision might have been made by a vice chancellor of the ANU. And let's assume that the vice chancellor, in making a decision, made a decision based on an enactment, or it may not be on the basis of an enactment. It could be on the basis of the general law. So in that case, because it is not based on the general law, it is not based on an enactment, then you cannot apply the ADJR Act. Neither can you apply Section 39B of the Judicial Act of 1903, because the decision is not made by an officer of the Commonwealth, because the ANU vice chancellor is not an officer of the Commonwealth. What is your recourse? Then you can have recourse to the common law. That is also a crucial point, because I think one of the students asked a question about what is the effect of the public and private divide, in the sense that we now see that the executive government has kind of transferred certain public service functions to the private sector. It has privatized some important functions, such as postal services, telecommunication services. In the States, it could be about the collection of garbage. It could even be about the maintenance of the immigration centers. It could also be about the detention facilities that belong to the Commonwealth. These have been privatized. So if a citizen, therefore, feels aggrieved by a decision of a non-government agency, which seems to be exercising certain powers that were traditionally identified with the executive, what is the recourse? You can't base it on the ADJR Act, because for sure the executive decision was not made under enactment. You can't rely on Section 75(5) of the Constitution or Section 39B of the Judicial Act, because it wasn't made by an officer of the Commonwealth. So where do you go? That's when the common law judicial review is likely to be available. Okay. Now, there's a comment from Bronwyn, which is quite long. If it's all right, I'm going to go through it. Manjo is, so my nickname is pronounced as Manjo, like banjo. Just wanted to clarify that. Is administrative law looking at whether the minister or the executive had the power to make the decision, and they have not enacted legislation that contravenes constitutional separation of powers doctrine? The government is attempting to operate as the executive and the judiciary. Okay. So when it comes to administrative law, the basic question that we have in relation to the judicial review is whether, when the executive made a decision, whether or not the decision was according to the law. Now, we assume that the executive perhaps has the power to make the decision. So we assume that there might be an authority there. But the basic question we ask is that particular decision, so we're looking at the decision itself, not the decision maker. Okay? So that particular executive decision, is that made according to the law? That's the scope of judicial review. Okay. Now, I haven't had a chance to cover a lot of the quiz or the questions, but I suppose, has the discussion been helpful so far, even if we didn't really cover the discussion questions? Would that be okay?
I think this is better.
Ah, okay, very good. Thank you, Michael, for that comment. Very good. Somebody else wanted to say something.
I think it covers the questions if you glean into what you've said so far.
Okay, very good, very good. Okay, so from Careless Helping, very good. Okay, any other questions? We're good so far?
Manjo, it's Bronwyn. Can I just clarify something with you?
Yes.
So if you're looking at jurisdiction, jurisdictional issues, is that the time you look at the issue of remedies, what's available as well? Or do you go through jurisdiction, just disability? When would you look at, because contingent upon the remedy you're seeking, is that what you're saying? Contingent upon what remedy you're seeking also informs your decision of how you're going to proceed with that matter?
Very good. So I think what Bronwyn is trying to raise here is a very important question, is when do you know, before you can apply for judicial review, are there certain things you need to kind of tick off to make sure that judicial review remedy is available? And we will see from the notes that there are 5 things that you typically have to consider. One is the issue of standing. So does the aggrieved or the applicant have locus standi, meaning has that individual been aggrieved by an executive decision? In other words, if that person has not been aggrieved by an executive decision, then that person has no locus standi. That person has no business coming before the court. Okay, so that's a question of legal standing. The second question we have is the question of justiciability. And what this tells us is that there are 2 aspects to justiciability actually. At its core, justiciability arises as to whether or not it is right for judicial review. In other words, at that particular time, is that something that should be examined by the court because it could be a final or operative decision, or is it an intermediate decision? And therefore, it shouldn't be subject yet to judicial review because there is no matter. There is, for example, no actual controversy. The second aspect of, it's over there. The second aspect of justiciability is whether or not it is something that is appropriate for the judiciary to examine. So there are certain matters which might involve national policy, political considerations, which might require the use of political decision making, and these are best determined by the elected officials of the government, meaning the executive or the parliament. So there will be instances when the courts will say, no, it is not justiciable because it doesn't involve legal questions or legal issues. It involves, however, political considerations. There's also as pointed out by Bronwyn, the other question we ask is, the question of, is there a ground for judicial review? Because if there is no ground for judicial review, so you can't say that the decision is unlawful in the first place, then in that case, there is no scope for judicial review. You also have to ask, fourthly, whether or not the decision is in fact an executive decision. So this is important because the point was raised earlier by Nicholas. What about a law passed by the Commonwealth Parliament? And let's assume that people are unhappy about the decision. Can you apply for judicial review? And the answer is no, because that is not an executive decision. And so therefore, judicial review is available only when you speak of a decision made by the executive. And fifth, it is important to determine whether or not you have an available judicial review remedy, because as we later on see, when you examine, for example, the case, certain cases, which we'll cover, I think, in week 5, we will realize that the courts have said that even if it agrees that the decision is contrary to the law, the courts are powerless to give particular remedies. So if, for example, you apply for a particular visa from the Department of Home Affairs, it could be a partner visa in behalf of your partner, and the Department of Home Affairs, is that the proper agency now, refuses to issue the visa. And let's assume that the decision is not according to the law. The question is, by an application for judicial review, can you ask, for example, the Federal Court or the Federal Circuit Court of Australia to compel an immigration officer to grant a particular visa? And the answer is no, because as we later on see, when you speak of judicial review, it is very limited. So when an executive decision is determined by the judiciary or by a court to be contrary to the law, what the courts will typically do is to remit it back to the original decision maker, or it will simply nullify the decision or set it aside. But so the effect is, if it sets it aside, it hasn't really provided you the particular remedy that you wanted. And it could be the case with Centrelink. The Centrelink refuses to give you a particular benefit. You go straight to the courts because you feel that the decision is contrary to the law. But the courts will not grant you the particular benefit that you wanted. It may set aside the decision, but it just leaves you back to the executive to run back to the executive to ask the executive to arrive at the decision that is according to the judgment of the court. But the court will not, in general, grant you the specific remedy. So those are the 5 things. Other questions? We're good. Now, before we miss it, we've actually covered most of the tutorial questions, but let's just go to the quiz, because I made a promise that I'd actually be very happy if most of you or all of you will end up getting 10 out of 10 for all the 10 quizzes. Now, what I do is that when we have a quiz, the weekly quiz, I cover a particular weekly quiz question in the tutorial. Not so much that I provide the answers, but I kind of address the certain principles behind a quiz that are being assessed. I don't provide the answers, but I kind of discuss the quiz. So let's just go through the quiz. Can I just ask, hang on, let me point out something. Sometimes you will, this is being recorded. Sometimes you will notice me at this point that I may speak loudly, and I kind of do this. I actually have a medical issue right now. I'm suffering from tinnitus, and that is the loud ringing of the ears. I've only gotten this on Saturday, and it's terrible. I can't hear anything here. And because of that strong buzzing sound, it affects my right ear. And so I can't really modulate myself. I don't really know if I'm speaking too loud or not. So you're gonna have to forgive me for today. I've gone to 2 GPs, and we're hoping that the problem is going to resolve itself. But unfortunately, that's my medical condition right now, and it's probably because I'm getting old. So we have, I was thinking, I'm still too young, but actually, in fact, I'm getting old. So anyway, quiz. Can I get somebody to volunteer to read the quiz question for us? Yeah, okay, okay. Yes. Can I get a volunteer to read the quiz question?
I'll do it. I'll do it.
Who's that, Kayla?
Yeah.
Yes, thank you, Kayla.
Shane Thomas was fired from his job as IT specialist of the Australian Advanced Information Technology Corporation, which was created under the Australian Advanced Information Technology Corporation Act 93. The termination of his employment was made under the general law and not under the Act.
Mm-hmm.
Thomas has approached you, a solicitor, for legal advice. He wants to know if he can apply for a judicial review under the Admin Decisions Review Act against the decision of the corporation.
Continue, please, Kayla.
Sorry, continue.
Yeah. Yes.
Okay, which answer is the most correct? A, he can apply for judicial review under the ADJR Act since the decision is of an administrative character, even though the decision was not made under an enactment. B, he cannot apply for judicial review under the ADJR Act since the decision was not based on an enactment.
Mm-hmm.
C, he can apply for judicial review under the ADJR Act since the decision was based on an enactment. D, he can apply for judicial review under the ADJR Act since he has legal standing even though the decision was not made under an enactment. Or E, all of the answers are wrong.
Okay, very good. Thank you. So going back to the quiz question, we see here that the corporation, or the Australian Advanced Information Technology Corporation, was created under the Australian Advanced Technology Corporation Act. Is that an enactment? Is the act an enactment? It obviously is. Hang on, before I get there, can you just give me an answer here? So just say A, B, C, D, or E. We've read through the facts, and of course, this is just for the purpose of getting information. What do you suppose is the correct answer here? From A to E. Is it A, is it B, C, D, or E? Can I just everyone to put an answer in the chat box? Mm-hmm. Okay. Very good. Okay. So I think everyone has got, okay. Almost everyone has gotten the correct answer except for one. Okay, so I'm happy with the answers there. Okay. And remember, I'm not gonna tell you the answer. You're gonna have a sense of what the answer is. What do you think is the correct answer here? Can somebody try to provide an answer and why? Can somebody pick up the mic?
Yeah, I'll have a go.
Yes,
Sarah Rogers here. I put down B. He cannot apply for judicial review since the decision was not based on an enactment because that I felt that it was made under the general law. So it's made under a contract. And so that it wouldn't come under, even though there is an enactment,
yes,
separate. The decision was made under the general law, i.e. the contract, and not the enactment. And there is a case. I can't remember the case, so I do apologise. I think it's Griffith University or it's another case anyway that says this, that it's under the general law and not under that.
Fantastic, Sarah. So both the Griffith versus Stan case as well as ANU versus Burns are on the proposition that Sarah stated that if an administrative decision is not made under an enactment but on the basis of a general law, you cannot seek recourse under the ADGR Act of 1970. Okay, very good. So we'll skip that. That was quite quick. Well done.
Could I throw 2 cents within? Yeah, I said all of the answers were wrong. I saw that one. And said, yeah, but to qualify for judicial review,
yes,
it has to be, the decision has to be unlawful.
Okay. And you're saying that there doesn't seem to be, to say anything.
Yeah, there's nothing there that says that's an unlawful decision.
So that's your reasoning. Okay. You're right. So, okay. That wasn't the thrust of the quiz. I understand where you're coming from, Keith. That's the lawyer speaking. Very good. It's not clear why, the termination was illegal in the first place. Okay. Okay. But let me just clarify. So you're right. If that's the point you're making, Keith, you would be correct because, why is the decision unlawful in the first place? But that is not the thrust of the question. The purpose of this assessment is simply to determine whether or not the decision is reviewable under the ADGR Act. So if that is the argument, you're correct. So that can be the problem with quizzes, right? Because the answers are too simplified. You actually have something in your mind, but you're made to choose something. But so I take what you said. But the safest answer, I think, would be that which the rest of the class is saying, because that was the thrust of the quiz, which is really to determine whether or not the decision is reviewable under the ADGR Act. But I take your point, Keith. That's a very good point.
Manjo, I nearly chose like Keith until, like Sarah, I went through and read those couple of cases that clarified what my decision was going to be, which is why I ended up with the decision I ended up with.
Okay. Yeah. So I should have put an assumption that assuming that there is a ground for judicial review. Okay, I should have made that clear. So let's assume for the quiz that there is a ground for judicial review. The question is the decision reviewable under the ADGR Act? So very good, Keith. I'll try to remember that next time because, sometimes I have it in mind that, everything is clear, but it turns out I'm missing a fact. So very good. I'll keep that in mind. Thank you.
Okay, not an issue, but just, I just couldn't see the connection.
Thank you. Very good. Fantastic. Okay. Now, we'll have a chance at going through one more question or even 2 questions. I don't mind. Can somebody read question 1 for us? Question 1? Tutorial question 1. Can I get a volume?
I'll read it.
Thank you.
After years of working as a disability support worker, Sharon Hills decided to set up her own business providing support to disabled persons. The Disability Support Workers Act, Commonwealth, requires that operators, owners or managers of businesses seeking to provide services to persons with disabilities must have a business licence from the Australian Department of Social Services. Such a business licence may be given only to persons who have had professional experience as a disability support worker for 5 years and who are of good moral character. The Act also provides that an application for licence must be made not later than 30th of June the same year. Sharon applied for a licence on the 18th of June. However, staff of the ADSS did not accept her application because her documents showing her years of professional experience as a disability support worker were incomplete. She returned on the 27th of June, Friday, to submit further documents, but these were still considered incomplete, and so her application was not accepted. On 30th of June, she returned with a complete set of documents on her professional experience, but was then asked to provide further evidence relating to her good moral character. She returned the next day on the 1st of July to submit the necessary documents. But the ADSS refused to accept her application because it had been submitted after the deadline. Sharon is frustrated and angry that her application was not accepted and has come to you for legal advice. Assume that the recourse to the Administrative Appeals Tribunal is not available. Advise Sharon on whether judicial review is available and why.
Okay, thank you. What do you think? Yes or no? Is judicial review available? Can you just type in the chat box, yes or no? Can I ask everyone?
Yes.
Type in the chat box, yes, no, yes, no. Okay, so there are two said no, a lot said yes. Nancy said she doesn't know. Okay. What do you think? Can somebody try to provide an answer? Lorraine raised her hand. Lorraine, yes.
She has recourse for the review.
Yes.
Because she meets all the criteria and she has standing because of violation of, well, imposed on her.
Very good. Go on.
That's,
You mentioned legal standing. Anything else?
legal. She has, hang on a minute. I've got it here. I wrote the thing out. Cause executive has not been fair in its dealings with assessing her application.
Okay, so there seems to be a ground for judicial review. Very good. Which could be on the basis of principles of natural justice being breached. Yes. Anything else?
Administrative justice is believed to be fair, has integrity, is non-judicial executive decision-making by government departments, authorities, and so forth.
Yes.
However, there are also other avenues for Sharon, which I thought she couldn't go under the merit review there, but I wondered whether it could be an internal review.
Okay, so that is correct. The answer here is that yes, judicial review is available, particularly with through the Administrative Decision Judicial Review Act, because this is a decision made under an enactment. So there is a decision. She is aggrieved by the decision, so she is standing. It is a decision that is of an administrative character because it was made by the DSS, which is an agency of the executive. It is a decision made under enactment, and it is a decision that is, not subject to judicial review because it is a decision. It's not an excluded decision because it is not a decision made, for example, by the Governor General. Okay, so very good. That's an easy question. Well done.
It's not an easy answer though, Manjo, because we can say yes, but the question I would suppose then would be if we get to a judicial decision, and it would be handed back to those that made the decision to reassess the decision, right? Because the judiciary can't force it, as we know. Yeah. The question is, could they then still delay it until the 30th of the following year anyway?
Okay, very good. Now, there are two answers to that, Nicholas, and thank you for pointing that out because that is a very crucial point. Because as Nicholas pointed out, even even assuming that judicial review is available and the court actually agrees with you, we know that given that judicial review is of limited means, the court can't order the executive to act in a particular way. So if that's the case, what's the point of asking for judicial review in the first place? There are two answers to that. The first one is this. Let's assume that there is a decision. Let's assume it's an immigration issue, and there is a decision made by the visa officer to eject somebody from Australia. Okay, so somebody's about, it could be a partner, it could be a partner of yours, it could be a friend of yours, and the visa officer said, nope, you need to leave Australia straight away. Okay, now the beauty of seeking judicial review is that the court can set aside that decision. So if the court sets aside that decision, there is no decision to exclude the person from Australia. So you've won. Even if the court did not say that that person has the right to remain in Australia, the fact that the court has ordered that the decision be set aside means that the person can stay in the meantime in Australia. Okay, that's one. The second advantage really of judicial review is that even if a court does not specifically tell or instruct the executive to act in a particular way, and let's assume that it is, for example, what is known as a writ of declaration, where the court makes a determination of what the rights are of a person, even if the court does not order the executive to act in a particular way, but if the court outlines or determines what the rights are of an individual, then in all likelihood, the executive, when it reviews its own decision, will try to abide by the determination of the court. So if the court says that the executive made a wrong determination in this manner, then in all likelihood, in most cases, what the executive will do will be to try to change its own decision. So it's doing it on its own. Change its own decision in order for it to be consistent with the determination by the court. So in a sense, there is a very strong influence by the court decision because it tells the executive what would be correct according to the law, except that the courts leave it to the executive to make the correct executive action.
Manjo, so is that when it goes back, is that the situation where it gets taken off, let's say, that junior that made the decision and gets passed up to a senior minister, like in the executive, so it goes up the chain for the second decision?
That all depends on the executive. It depends on their own internal rules. You would suppose that in that particular case, it would probably be reviewed by a superior officer within the executive. I would imagine that would be so. Now, Nicholas, however, is pointing out a crucial point. So what Nicholas is actually telling us is that assuming that an executive decision has been made and a person is not happy with that decision, so the person is aggrieved by that decision, you don't really have to seek recourse straight away through merit review. You don't even go straight away to the courts. You can actually seek an internal review. And that is, you go back and say, can I ask that somebody reviews your decision? And that is something you should be considering, the process of internal review. Now, Damien is saying something here, but it would have been complete by 30/6 if it weren't for the procedural unfairness they imposed. Hang on, what are we talking about here? Okay. In relation to the tutorial question. Okay. So for the purpose of the tutorial question, we are assuming that there has been a breach of procedural fairness. We are assuming. Okay. And so now whether or not the court will agree that there has been a breach of procedural fairness, that is for the court to determine. The only point for us is there a ground for judicial review? And you can argue that there is a breach of procedural fairness or the principle of natural justice in this case, because the person was never given an opportunity to provide the documents by the deadline. Okay. It's 7:05. Do you want to continue with one more question, or can we end it now?
No, keep going, Manjo.
Okay. Okay. Very good. Thank you, Nicholas. Question 2. Can somebody read question 2 for us? Thank you, Nancy. Continue. Okay, we'll continue. For those who need to, drop out and move on to different tutorial, please feel free to do so. Now remember, all the tutorials are being recorded, and immediately after the tutorial tonight, I'm gonna put up the recording in YouTube and then put the link in Moodle. Can I ask somebody to volunteer to read question 2 for us?
Yeah, just before they do, sorry, Manjo, got to go. Really, really enjoying the discussion. It's been great.
Okay, thank you, Keith. Thank you so much for the feedback. Thank you. Thank you. Tutorial question 2. Can somebody read the question for us?
I'll do it if you're not sick of the sound of my voice. But,
yes.
Okay, the Australian newspaper reported that a federal government commissioned report has detailed widespread and systematic abuses of boat refugees in Australia's refugee facility in Manus Island. The Australian Refugee Consortium, an Australian non-government organisation, asked the Minister for Immigration and Border Protection, who commissioned the report, to publish it, but he refused. The consortium has approached you for legal advice on whether it has valid grounds to apply for judicial review of the Minister's decision not to publish the report. Give your advice.
Very good. What do you think?
I felt personally that this Australian Refugee Consortium, I questioned the fact whether they would have standing.
Aha, very good. Why is that?
Because I didn't feel that their interests were personally affected.
Aha, very good.
And there was no matter as such, so it's
Aha.
all that's interrelated. Initially, that was my feeling on that.
Very good. Very good. What else? There's another point there.
So I felt that maybe it was non-judiciable.
Okay, very good. Tell us about that, Sarah. What do you mean by that?
I felt that because it's an immigration and border control issue, that it was might have been under Schedule 1 and might have been excluded under that action, or nevertheless, even if it wasn't, perhaps it would be a high policy decision of the Australian government because it's to do with the exclusion of Asians and things like aliens, to not to involve the courts within that, and I felt that the courts were involved.
So the third point that Sarah was pointing out was the issue of justiciability. She was saying that the executive decision to publish it or not seems to involve a policy consideration on the part of the executive, and the executive may have reasons why it wouldn't want it to be published. It could be because it might hurt or harm the reputation of Australia. It might mean that by publishing it, it may provide impetus for some bad characters to make use of it to try to destabilize Australia and so on. But the whole point is that it seems to involve political considerations. It is not a legal issue. And because of that reason, it is non-justiciable. So on that score, as Sarah pointed out, she wouldn't advise that judicial review be applied for, mainly because one, the consortium doesn't have the legal standing. Two, it is non-justiciable. Was that it, Sarah?
Yeah, that's pretty much it. The only other question I had was, because he refused to publish the report, I noticed under Section 13 of the ADJR Act that there is an obligation, if they follow the correct procedures, for the minister to provide a report and provide written reasons. Now, if that refusal there, is that technically, if it was a non-political situation, it was a different situation, is that decision then, would it be judicially reviewable?
So assuming that there was a law which said that that report needed to be published and the report was not published, the question then was, is that going to be justiciable? In that case, that would be justiciable because it involves a legal question. Because in the scenario that you pointed out, Sarah, we're assuming that there is a law which provides that the report has to be published. There is a legal obligation. And so therefore, if the executive refuses to comply with its legal obligation under that particular statute, that becomes a legal question. Okay, very good.
Manjo, in those situations though, don't you find that what happens is most of these organisations then pay for a lawyer to be appointed to the refugee, so that it has legal standing then through the lawyer on behalf of the refugee then to challenge?
That's true. So in that case, that's a good point, Nicholas. In that case, if a lawyer were to be appointed for the refugees, then potentially they would then be able to hurdle the issue about local standing. But the problem remains, is that a justiciable issue?
No, it's not. And I understand that. I'm just trying to get that point out, that there's all these levers that you have to jump over, because I think at the end of the day, the issue with the executive there is it's also, border protection is also covered under the Constitution as well, isn't it? So it's well endowed in the executive to make the decision it did.
That's right. Okay. So,
Manjo, it's Bronwyn. Can I just ask you one more thing around that Section 13 provision?
Section 13.
So if it was not an issue in terms of justiciability, but let's say you had another ground for review, would you exercise that Section 13 to try and get reasons or more detailed reasons?
Okay. So Are you talking about the ADGR Act?
Yes.
Okay.
Yes.
So let's backtrack a bit before I address the point by Bronwyn, because this is a crucial point. The basic question that was initially being raised by Bronwyn is this: when the executive arrives at a decision, is there a legal requirement that the executive must provide a reason for its decision? That is the core question there. Let me repeat the question. So when the executive makes a decision, is the executive required to provide reasons for its decision in the absence of a requirement by a statute? Okay, so in the general scheme of things, must the executive provide reasons for its decision? And we will later on realize, I think when we discuss principles of natural justice, that in general, the answer is no. There is, in the absence of a statutory requirement, the executive is not required to provide reasons for its decisions. So we're clear about that? Now, so if that is the case, the question then of Bronwyn, I think, was, can the executive then be compelled to provide reasons for its decisions? So that's the beauty, again, of the ADJR Act, because the moment that an executive decision is made under an enactment, we can suppose that there is actually a duty then on the part of the executive to provide reasons for its decisions on the basis of Section 13. Because what it tells us is that even if somebody does not apply for judicial review under the ADJR Act, the fact alone that an executive decision is made under an enactment presupposes that the executive has a duty under Section 13 of the ADJR Act to supply reasons for its decision, even though a particular statute may not require the executive to provide reasons for its decision.
Yeah, that brings me back, Manjo, to the reason why I said that a lot of these organisations appoint a lawyer to an individual, because then the executive has to provide the individual with the answer, and the individual hands that over to the lawyer, and the lawyer hands it over to the group that's paying the lawyer to do the work for the individual. So in a roundabout way, they get their report anyway.
Not always, because again, if the executive refuses to, for security reasons to provide reasons, somebody will have to go to court to do that. They'll have to.
And then you end up with a redacted document that's got nothing but every second word that you can't read anything of anyway. We've seen that happen as well, man.
It does happen. You're right. Very good. Okay. It's probably time for us to leave this, right? Okay, it's about 7:13. From Damien, Doctrine of Responsible Government or Avenue. So Damien is actually correct that assuming that somebody is unhappy with an executive decision, maybe sometimes what is needed is actually an overhaul of the law itself. You go to the Commonwealth Parliament and get the Commonwealth Parliament to change the law. Sometimes that is the correct way, perhaps, of doing it. Okay, so thank you everyone for a very lively discussion. I think we covered most of the important principles to be covered in this topic. And thank you for your involvement and for coming here tonight. See you again next week. Okay.
Thanks,
Thank you.
Thanks, Manjo. Bye.
Thank you.
Bye.
Bye.